Welcome to Middle Class Matters. Today, 21st June 2023, Business News in English. Let's see the continuation, part 13 of Report of the Expert Committee constituted by the Honorable Supreme Court of India to inquire into the Adani issues. Committee's conclusions. Para number 104. The committee therefore returns the following conclusions. A. The committee would like to reiterate that it is only setting out the position in the law with specific regard to whether there has been a regulatory failure. B. In the facts of the case, it is evident that SEBI has been getting feedback about such transactions from the market and has responded by amending the regulations. Therefore, it would be difficult to arrive at a finding of a regulatory failure on the legislative side when SEBI has been intervening to regularly raise the bar in its stipulation of desirable conduct. C. However, while the legislative policy has proceeded in one direction, enforcement policy cannot move in a diametrically opposite direction. The manner of enforcement ought to be consistent, coherent, and decisive in consonance with publicly declared law. D. Once SEBI has taken the legislative position in November 2021 that transactions between related parties and subsidiaries of the listed companies would come within the coverage of related party transactions only with a deferred prospective effect, that is, with effect from 1st April 2022, it cannot assail past transactions effected even before November 2021 as being violative of the law that has been stated by it as not being in force when the transactions were effected. E. Likewise, once SEBI has made a legislative stipulation in November 2021 that transactions with unrelated parties would fall within the scope of related party transactions if it can be shown that the intent and purpose of the transaction is to benefit a related party with deferred prospective effect with effect from April 1, 2023. It cannot assail transactions effected in the past as being in violation of law that has been stated by it as not being in force when the transactions were effected. F. Invoking the spirit of law would not suffice to pursue a credible means of investigation into the matter, keeping a cloud over the transactions. G. Assuming the law to have been applicable when the transactions were effected, it must be noted that the Honorable Supreme Court has repeatedly held in matters relating to securities laws that enforcement must be taken up with promptitude and reasonable proximity of time with the occurrence of the events suspected to be violative. H. SEBI has been probing the matter since October 23, 2020 after receipt of complaints in June 2020 and July 2020. The amendments to the definitions of the terms related party and related party transactions were made in November 2021 and took effect on April 1, 2022 and April 1, 2023 with material and substantive changes being made. Para number 105. The committee believes that there is a need for an effective enforcement policy that is coherent and consistent with the legislative position adopted by SEBI so that precious regulatory resources are not expended on regulatory action that is infirm on the ground of applying the law retrospectively. Price manipulation in Adani scripts. Para 106. In dealing with the remit of assessing if there has been regulatory failure, one of the points on which SEBI is to apprise the committee is whether there has been price manipulation in the Adani stocks. Para 107. The committee called for a briefing from SEBI on the historical price movements in the Adani stocks and what SEBI's approach had been as part of its surveillance of the market. The committee also asked the invitees to comment on the subject. Para 108. SEBI pointed out that it has been in place automated